Hey everyone, this is Dr. Pollock, and in this video, as you can see, we're going to talk about the federal judiciary. All right, so the judiciary, first of all, it encompasses the Supreme Court of the United States, which we've talked about at numerous points in time in the semester so far. For instance, we talked about how the Supreme Court often has the pivotal role in defining the boundaries of civil liberties. So we're going to talk more about the Supreme Court. That'll be a major point of our discussion. We're also going to talk about other levels of the federal judiciary, which we haven't really talked as much about yet in the semester. So the district courts, the appellate courts, we're going to take a broad view on the judiciary and explain how it works, what it does, and how it relates to certain other branches in government. Before we get into the main part of the discussion, though, let me just take a few moments. So I'd like to start out, of course, when there's things going on in the actual political world to refer back to and relate to our actual discussion of the day. I think it makes sense to start out with that. And so, in terms of the Supreme Court, I guess a few things going on. The overall lay of the land is that, like many other parts of society, the Supreme Court has been affected by the viral outbreak. It hasn't been doing as much, so there's not as much breaking news or ongoing news as far as the Supreme Court goes to talk about. One thing maybe you did hear about if you've been paying attention to the news is Wisconsin had this primary last week, the presidential primary, and there are a few other elections going on where the Supreme Court had a say in that and how it worked out. So there's this last minute order issued by the governor of Wisconsin to delay the election. That got overturned by the Wisconsin state courts. Later on, it goes into federal court, this case, to where a lower level court, a district court, says we're going to allow for mail-in balloting, I think a week after, up to a week after the actual end of the election. The U.S. Supreme Court steps in and they say, no, we're not going to allow that sort of major change in such close proximity to an election, which this was a pretty controversial decision. The majority of the court, it was a 5-4 decision. The majority of the court says, we're not comfortable allowing this last minute change to the way an election works. For the justices and others, if you read commentary on this, many people were upset that potentially this was that the court should have allowed for the election to be altered a little bit given the emergency situation. This is one thing the Supreme Court has been involved in lately. Overall, though, this is another article I found just to summarize what I said about the status of the Supreme Court and its rulings being delayed by the viral outbreak. This is an article, a blog post actually, which I haven't fact-checked it, but I would assume it's an authoritative look at the data. Looking at the number of cases within the current term that the Supreme Court is actually ruling on, and the summary of this post that I found is just that the court is on pace to issue the least number of rulings since the Civil War. So you have to go back a while. The number that the court in its current term is going to reach, according to this article, is projected to be 56 rulings. And that's actually, trying to bring up this graph. You can go back and you have to go back to the 1860s and get to another court that made such few rulings. And this is something that's certainly being affected by the coronavirus. Right? The fact that a lot of the cases, so there, if you were paying attention to what was on the docket for this term, there were decisions relating to abortion, this Louisiana abortion law, which maybe some of you are familiar with, whether it's a legitimate restriction on abortion there. There's questions, there's a case involving civil rights and whether specifically the 1964 Civil Rights Act is applicable to gay or transgender people. DACA, we talked about, deferred action for childhood arrivals, this executive order that Obama put into place, which Trump subsequently revoked. The court is considering whether or not it was allowable for it to be revoked the way that Trump did. There's a case involving the Affordable Care Act or Obamacare. So there's a lot of politically important matters before the court, which have been delayed in terms of the final ruling. Final thing I wanted to mention as far as the current event is this, that in order to sort of break up the current logjam and the delays, this is interesting. So the court has actually announced, the Supreme Court, that they will begin to conduct their proceedings remotely, right? So here this isn't a synchronous teleconference, but the court is going to be doing something similar to what we're doing, in that they'll be using, I don't know if it's going to be Zoom, but some teleconferencing software to actually hold their arguments, oral arguments, as well as conferences, I believe, remotely, right? And this is something that the court's never done. The court has never, first of all, met remotely, and second of all, the court has never allowed for its proceedings to be available to be viewed by the public. Okay, so both of these things are going to change. They're going to have these remote sessions, and they're going to be viewable by the public. One thing, I'm guessing most of you don't recall this, but one thing that our documentary on Congress talked about just briefly is that we had this momentous occasion in 1979 when, for the first time, television cameras were allowed into the congressional chambers, right? That's where we get C-SPAN from, to where you have a network where you can, whatever's going on in Congress, you can tune in and watch actually what government is doing. That sort of thing has never been available at the Supreme Court before. And so for the first time, really, we're going to get a chance, if any of you want to, I don't know how many of you will avail yourself of this opportunity, but we'll have the chance to actually see what goes on during the Supreme Court. I mean, we know more or less what happens, the structure, and that's actually a topic we'll talk about when we get into the lecture, but we'll actually get a chance to watch it unfold here. So this is just, we had this backup of cases, and the Supreme Court is taking these actions to understandably try to move things along. So we're still in social distancing, and just the way it shakes out is a lot of the justices on the Supreme Court tend to be in the age range to where they'd be vulnerable to COVID-19, adverse outcomes, I would say. Everyone's vulnerable, but certain age groups, older people, tend to be more prone to severe outcomes. And so here we're going to have remote Supreme Court sessions and perhaps get some of these cases I just mentioned eventually rolled on. Okay, so getting to the lecture now, I wanted to start out just giving a brief backdrop on the role of courts in general. I want to point out the difference between federal courts and state courts just briefly. I'll start out like that, and then I've got a few slides I'll go back and forth to. One set of slides involving just the constitutional basis, what the Constitution says about the federal judiciary. And from there on out, I'm going to talk about what we'll refer to as the judicial hierarchy, so different levels in the federal judiciary. Right? We've talked about the Supreme Court a fair bit. That's obviously at the top of the federal judiciary. We'll be talking about what the courts are, which are also important, not as probably important as the Supreme Court, but also important at lower levels in the federal judiciary. Then finally, I'll wrap up just with a discussion of Supreme Court appointments. Okay, and we've talked about the general, I should say, way that federal appointments are made. The president makes the appointment, and the Senate has to confirm. We'll revisit that discussion just in the specific context of the Supreme Court, which whenever there's a Supreme Court justice, this tends to be the most high stakes and the most important appointment a president will ever make. It's going to be very politically charged and controversial in the last couple of appointments. And so we'll talk about that briefly toward the end. Or it may not be brief. I don't want to overpromise, but let's get going here. Okay, so the term judiciary here, we're fundamentally getting down to the institution in government that's responsible for dispute resolution. So whenever individuals, or maybe the government and an individual, or maybe different parts of the government disagree with one another, the court is the part of the government in society that has the authority to go in and adjudicate which side is right, which side is wrong, and institute whatever measures are necessary to reflect that. Okay, so we're going to talk specifically about a couple of different types of cases. So broadly speaking, we can take any sort of legal case and put it into one of two different bins. Okay, one of which would be criminal cases. Okay, so this would be an instance in which somebody violates a law. Okay, that's the key here. Some person is accused of doing some action that's against the law, and the government is prosecuting that person for it. So this is maybe what many of us think of when we think of trials, or court cases, somebody accused of violating the law going into a criminal case. Okay. And I don't really know that I want to belabor the point too much as far as criminal cases go. I think many of you will already have been aware of the basics, right? We're talking about the person being prosecuted. That's what we would refer to as the defendant. In this case, the government would be what's known as the plaintiff, the person, the entity, I should say, in this case, bringing the complaint forward. The government, usually this would be a prosecutor or a state or district attorney saying, okay, we have evidence that this person broke some law. They're going to go into court and they're going to present some evidence or legal argument supporting the claim that the person broke the law. The defendant will have the chance to counter argue, present evidence on their side, present legal arguments if necessary on their side to try to argue that they should not be convicted of the crime, right? So here, when we talk about criminal cases, just to emphasize this point, the key here is that in order to levy criminal penalties onto somebody, it has to be a violation of a law, right? We exist in a society where if you're going to levy some, here we're talking about in criminal cases potentially imprisonment. In order to bring this sort of charge against somebody, it has to be in reference to a law that's been passed. So in the federal government's case, we're talking about Congress, right? Congress has to have passed a law that's made whatever the action in question is illegal. Right? Another point I wanted to emphasize here is in the background here. We're talking about criminal cases, and we get into the other type of case. This will be sort of a similar scenario. We're going to talk in our lecture here primarily, early exclusively, I would say, beyond this particular moment. We're going to talk exclusively about federal courts. Okay, so federal courts would be responsible for federal crimes. I'm going to put some examples down here in a second. Operating simultaneous to federal courts, each state, so here, for instance, in North Carolina, has its own state criminal system. It has its own state code of laws. It has its own state courts, state prosecutors prosecuting state crimes. By and large, so almost every case which you would think of as being a crime that people get prosecuted for, most of them are going to be in this column of state crime. So things like just assault, battery usually goes along, or at least oftentimes goes along with assault, theft, most homicide, DUI. Okay, so these are all things that we would, people are very often brought into court and they're accused of doing. These are all the sort of things that a state court would be responsible for. So it's not the federal court that's going to be trying most murder cases or trying most burglary or anything like that. Specifically, the federal courts are responsible for actions that are against federal laws. Okay, which there's going to be a little bit of overlap sometimes with state laws, but most of the time federal law is interested in other sorts of things compared to what state law is all about, right? So here, in terms of federal crimes, you might have, in general, cases that traverse state boundaries. Okay, so for instance, one example here would be kidnapping sometimes, or kidnapping or abduction. If it happens within one particular state, it would be in this column of state law. If it's something that traverses state lines, sometimes the federal government might get involved. That's just one example, but in general, cases that go beyond different state boundaries, oftentimes the federal government takes over their prosecution. Drug trafficking, for instance. Okay, so if you're somebody who's bringing in drugs from out of the country, or you're transporting them around the country across state lines, this is something that very often, really, in any of the case I'm describing, not very often, but really in any of the cases I'm describing, trafficking drugs within the country or into the country, that's going to be a federal prosecution. Securities fraud is another example I had in mind. Okay, so insider trading or misrepresenting your activity in trading, so things like this. So things involving financial transactions, maybe getting beyond just securities. These are pretty much going to be federal prosecution. The state can sometimes have a role, but these are going to usually you're going to have federal activity as well. Mail fraud. Okay, so the post office and the mail system, that's something that's handled at the federal level. And so if you're somebody who is accused of violating or using the mail system for criminal activity, it's something that potentially is going to be a federal prosecution. Terrorism, okay, that's something to where there are federal laws on the books. Okay, so here, the point of elaborating this is just to note, it's different types of crimes that are going to be handled in the federal criminal system compared to the state criminal systems. And so again, before I leave this point, just to reemphasize, most criminal prosecutions are happening in this column, the right side. It's not something we're going to talk a lot about in this class, the state court system, but it's something that's very important and relevant, right? It's just not really in the purview of this class. We are focusing on the federal courts, and so we're going to be, if we're talking about a crime, we're going to be in this column. In general, though, this discussion is not going to be so much focused on criminal prosecution. So as I mentioned, this is getting back to the overall discussion. The criminal cases, this is one type of case that the courts may hear. Another case which we are more or less going to be more interested in, that wasn't a great way to put it, but oftentimes they're going to be more interested in, would be civil cases. Okay, so let me spend a few moments just discussing what a civil case is. There are a couple of different types. Okay, so this is going to be not involving violation of the law. This is going to involve a person, group, sometimes not just one person, but multiple people, sometimes an organization. Filing suit against another entity to recover damages or prevent some action. So you maybe get the sense from this definition that there are a lot of different types of civil cases. So this is a bit of I'm going to try to simplify here. So one example of a civil case, this maybe wouldn't be a federal civil case, but one example of a civil case is that somebody goes into a store, they slip on a wet spot in the store and they injure themselves and want to sue the store. Right? That's sort of a stereotypical example of a civil case. Maybe of more interest to us, I mentioned a few different types of civil cases earlier in the lecture. The state of Louisiana, they passed an abortion law that restricts the presence of abortion clinics, and some people think that's illegitimate. Well, those people can sue the state of Louisiana to try to prevent that action from occurring. Or Donald Trump, the current president, passes an executive order saying he's revoking the DACA program, and some people think that's an illegitimate use of presidential power. And so they sue the administration to try to prevent that from happening in a civil case. Right? That's the type of case we're going to be most interested in, at least for our purposes. The other is not to trivialize civil cases that involve recovery of monetary damages or anything like that, but for our purpose, we're most interested in the court's role in adjudicating actions by government. Okay, so whenever the government is doing something that a person or organization or group or whatever thinks is illegitimate, the courts are there to hear whatever the argument is and determine whether or not the action in question is actually allowable. Okay, this is probably, for our purposes, what we're most interested in terms of what the federal judiciary does. It's part of this overall system of checks and balances to where if somebody thinks they've been aggrieved by the government, the courts are there to hear whatever the argument is and determine whether or not they have a legitimate case. So I hope that was clear. This section is really giving you a little bit more background than is strictly necessary for our discussion, but I think it's just good to know in general what the courts do and how they work. And this is a topic that if you're interested in, there are classes available that would get into a lot more detail as far as state courts and what various courts do, and obviously criminal proceedings, which we're not going to talk too much about. So for our purpose, I'll leave this part of the discussion here. Okay. So what I wanted to transition to now is a discussion of what the federal judiciary actually looks like, how it's organized, what the different levels of it are. Okay, so I'm going to start a new heading here called the judicial hierarchy. Okay, and I'm going to leave plenty of space down here to write. For now, though, before I get into this part of the notes, I want to just refer back to the Constitution, what it says about how the judiciary is arranged. Right? This is something that we've done very frequently throughout the class, right? We reference the Constitution, and oftentimes it serves as the framework for these various branches or parts of government. Okay, so here I've got a few excerpts taken out, specifically of Article 3 in this case. Right? We talked about Article 1, setting the framework for Congress, Article 2, setting the framework for the presidency. Article 3 deals with the judiciary, and before I get into the specifics of what it says, one general point I wanted to make is just that there's relatively little here in Article 3 compared to the other two articles that I just mentioned, right? In terms of the length, Article 3 is the shortest. In terms of the specifics, there are probably fewer specifics and details about how the courts are going to work compared to details about Congress or the presidency, right? So in some sense, the Constitution provides a bit of a vague mandate as far as the arrangement of the judiciary goes. That being said, there are a few different provisions here that I wanted to highlight, in which you guys will want to be aware of, and which will be relevant for us going forward here in the discussion. First, you note I have a few bolded sections here, and these are going to be the ones I focus on, a few bolded phrases, I should say. Okay, so the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Okay, so just to decompose this, there are a couple of relevant parts of this bolded section. The first being that the Constitution identifies a Supreme Court. Okay? So it says we're going to have a Supreme Court. That's a constitutionally mandated institution of our government. In fact, this is the only part of the judiciary that the Constitution says has to exist. Okay? When we get into the discussion in a second, when I talk about the appellate courts, the district courts, what we would refer to as the lower level courts, the Constitution doesn't say anything about those other than Congress, getting to another part of this bolded section, Congress may from time to time ordain and establish them. Right? So here it's talking about these inferior courts, which the framers foresee a need of. They don't spell out exactly what they're going to look like in the Constitution. Rather, they give Congress the authority to pass laws to establish these courts. Okay, so we have these districts, we have these appellate courts. That's all passed through legislation by Congress. It's not that that the Constitution says that they have to exist. These lower courts are filled in by Congress, and so Congress is responsible for filling in the details in this case. Right? The only part of the court that the Constitution actually says must exist is the Supreme Court. One other bolded passage here. So this clause continues on to say the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. Okay. The bolded part here, during good behavior, just the practical application of this is just that judges serve lifetime terms. Okay. A judge that is not in good behavior, so a judge is misbehaving, could potentially be impeached and removed from office through that process we've discussed. That's happened at various points in time. Otherwise, though, the judge, once sitting on either the Supreme Court, or this also applies to the lower court, so a district court judge or an appellate judge, they can stay at that position for as long as they want, up until their death or up until they choose to voluntarily retire. It's not as though you're term limited. It's not as though you have to be reappointed at any point in time. Once you are appointed and confirmed by the Senate, you can serve in that position for as long as you want. And this is a pretty dramatically different arrangement than other parts of the government that we've discussed. And just to preview, I guess, one other discussion we'll have toward the end of our lecture, this is one reason why appointments for judges are so politically controversial, right? Because once you get a Supreme Court judge or even a lower court judge, they're there for usually decades, right? So it's very high stakes when these judicial seats come up for appointment. Okay, this is getting to section 2 of Article 3. A couple of key phrases here before I read the actual clause. Both of these you want to be aware of. One here being original jurisdiction, the other being appellate jurisdiction. Okay, so let me I think this will make more sense. This overall clause will make more sense if I define these terms before reading it. Original jurisdiction, this is referring to a court having the authority to be the first court to hear a case. Okay, so original jurisdiction means this is the first court to hear a case, whatever the case is. I'm not giving you a specific example, but just in general, if a court has original jurisdiction, it's the first court to hear a case. Okay, this is in contrast to this term, appellate jurisdiction. Okay, when a court has appellate jurisdiction, it means it's hearing an appeal. Okay, that's where the term appellate comes from. It's referring to an appeal. Appellate jurisdiction means a court is reviewing some ruling from a lower court. Yeah. So I hope the contrast here is clear, right? So when a court is hearing an appeal, it's not relitigating the entire trial. It's just reviewing what the court ruled, and it's making sure due process was followed. It's making sure the law and the Constitution was applied appropriately. And if an appellate court decides something wasn't applied correctly, it can redress that problem. It can say the lower court ruling is no longer valid. In fact, what has to happen is what we're saying, right? So the appellate jurisdiction gives a court the authority to rebuke, and undo a lower court ruling. Okay, so again, original jurisdiction, the first court to hear the case. Appellate jurisdiction, you're reviewing some other court's ruling. Getting back to our actual clause here, what this is all going to be applied to the Supreme Court now. This clause is describing the jurisdiction of the Supreme Court. So this is in all cases affecting ambassadors, public ministers, consuls, those in which a state shall be the party, the Supreme Court shall have original jurisdiction. Okay. And so there are a select few types of cases in which the Supreme Court has original jurisdiction. These are very rare, though. So what's in these braces, these brackets right here between them, this is rare. It's extremely rare that the Supreme Court is acting as a court with original jurisdiction. It can in a select few cases, but it's pretty rare. By and large, really like 99.9% of Supreme Court cases are going to be appeals. Okay, so in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. Okay, so whether we're talking about the Supreme Court hearing a criminal case involving some alleged violation of federal law, or a civil case, most of the time it's going to be an appeal. Okay, so some district court has already ruled, or maybe the circuit court, and we'll talk about these different lower courts, has already ruled, and the Supreme Court is hearing it as an appeal. Okay, so here the Supreme Court is primarily an appellate court. This is, I don't know if this is something that you guys were aware of or is clear, but I just wanted to illustrate that as well. The Supreme Court, by and large, is not having trials. Okay, the Supreme Court isn't usually going to bring in witnesses and have a jury or anything like that. Really, it's never going to have a jury. The Supreme Court is there as an appeal to review cases and determine whether the law, whether the Constitution, whether due process is followed, and if not, to change the ruling in some way to correct the situation. Okay, so the Supreme Court is an appeals court. Okay, so getting back to our notes here, let's talk about what the actual judiciary looks like. So this is all to set up this discussion of the judicial hierarchy. And by hierarchy here, I just mean that things flow upward. Okay, so at the upper reaches of the court, the highest court in the land is the Supreme Court. Okay, as I just mentioned, though, the Supreme Court is not where most cases originate. Okay, in terms of the federal judiciary, most cases are actually going to originate in what are known as the district courts. Okay. So this is where most trials are going to happen. Okay. This is where, first of all, most cases start. Most federal cases. Let's stay precise in our wording, I suppose. And this is where the actual trial's going to occur. So here you'll have a jury. You'll have a jury. You'll have witnesses if need be. And so everything you would envision happening in a trial, it's going to be happening here. So this is the lowest level of our federal judiciary. And again, this is one of the inferior courts that Congress establishes. So Congress has to pass laws to say we're establishing a district that's in this boundary with this many judges. Okay. And in terms of the size and scope, the district courts are the largest component of the federal judiciary. So they're, in the Supreme Court, for comparison, there are 9 justices on the Supreme Court. That number also set by Congress, but there are 9 justices on the Supreme Court. There are actually 673 positions in the district courts. Okay, there aren't always going to be exactly 673 judges just because you have this appointment process that sometimes gets delayed. So sometimes you'll have fewer, really all the time you'll have fewer than 673, but that's the number of positions that Congress has established. And this is spread out across 89 districts. Okay, so for most states, they're going to have multiple districts serving all of the federal cases that are going on locally at that state. This map here, this will be something we refer to a little bit. This is showing you, actually this one is probably better to look at for district courts. This is showing you the state of North Carolina, which I'm sure you guys recognize. Here we have, for instance, just to illustrate, we are in the district court for the Eastern District of North Carolina. So everything in green here, this is one federal district. Okay. There are 2 other districts in North Carolina, as you can see. There's a district here in the western part of the state. Okay, and then this, if you can see the boundary line here, there's another district in the central part of the state. Okay, so in the state of North Carolina, there are 3 separate districts. We happen to be, you see Raleigh has the star here. We're the capital of North Carolina. We actually are where at least one of the district courthouses are. So here, I don't know if any of you have, I don't think I've ever driven by this building, or else I haven't recognized it, but this is the Terry Sanford Federal Building on New Bern Avenue, to where hopefully none of you are ever, indicted for a federal crime, but if so, the upshot is you don't have to go very far if you're in Raleigh. You just go to this building, and this is where your trial would occur, right here in Raleigh. Right. And so this is, again, the district court, the lowest level of the federal judiciary. It's where our trials are happening. It's where, it's where all the cases are going to originate, outside of very few specific types of cases that are originating here in our district courts. Okay. So in this scenario, the unfortunate scenario I just mentioned, to where you're indicted for some crime, some federal crime. Imagine you're indicted and convicted. That's, again, an unfortunate situation. That's sometimes, though, not where a federal case will end, though. Okay. I mentioned this is a hierarchy, so what will often happen is cases start at the district court level, and they will progress onward if somebody wants to file an appeal. So if somebody's, they feel aggrieved, they feel the law was misapplied, or something was unfair about the way the judge behaved, or the jury behaved, or the way, maybe there's a constitutional provision in question. People have, defendants, whoever loses at the district court level, they have the automatic right of appeal upward to the next level in the judiciary. I'm going downward, but you know what I mean, I hope. This next level would be the circuit courts of appeal. Yeah, this is a higher level of the court than the district courts, and as the term applies, this is an appellate court. Okay, so this is what we would refer to as an intermediate court between the Supreme Court and the district court. So this is, I described the difference between original jurisdiction and appellate jurisdiction earlier when I was in the slides, and so the same thing is here. The circuit courts of appeal, if somebody appeals to this level, they are saying something was misapplied in my trial, and I want some other judicial body to hear my argument. Okay, so again, there's no actual trial happening here. They're not bringing back the witnesses. They're not having every argument. What's happening is just the person bringing the appeal will explain why they think they're aggrieved, and the appellate judges will determine whether or not they agree. And if they do agree, then they can reverse the lower court's ruling. Okay. One key here. Okay, but actually, before I get to that, let me just give you, here this is a relatively smaller group compared to the district court judges, 179 judges in this case. Okay, so smaller than the district courts, but much larger than the Supreme Court, across 13 circuits. And this is I have another map here to illustrate this. This is a national map, and you can see the various circuit courts. Okay, you see in this case, they're for the most part spanning, I think all of them actually spanning multiple different states. Okay, so you see here, North Carolina is included within this 4th Circuit. Okay, so North Carolina is within a circuit court, a federal circuit court that also includes South Carolina, Virginia, Maryland, West Virginia, and you can see all these other circuit courts. It's this federal appeals body, which is encompassing multiple different states. And so here, if again, if you're in the situation to where you lose your case and you want to appeal upward, you would go here. This is the courthouse for the 4th Circuit. This is actually in Richmond, Virginia. So you'd have a little bit of a drive. If you wanted to appeal your case, this is where you would go, the courthouse in Richmond. Getting back once more to the notes, the important distinction here relative to what we'll talk about in a moment. So this is an appeals court, the Circuit Court of Appeals. And in fact, if you are a loser at the district court, you have an automatic right to appeal at this level. Okay, this is a key. This is a no questions asked appeal. If you lose in your district court case and you want to file an appeal, you can do so and have your appeal heard. And you have that right? There's no hoop you have to go through. There's no process to determine whether or not your appeal will be heard. It's automatic. Okay? It's worth noting, I suppose, also that not every case will be appealed. In fact, most cases aren't appealed. And so this is just because if you're trying to appeal, it's time consuming. It requires resources. Most appeals fail. And so you have an automatic right to appeal. It's just that it's not all, people aren't always going to avail themselves of it. But it's here. You can appeal if you want to. The contrast I wanted to draw here is that when we progress from the circuit courts of appeal to the Supreme Court, okay, which would be, if you were predicting, this would be the next level we're going to talk about. The Supreme Court, the name implies, and we've discussed this as being the most authoritative, the highest legal authority in the land. You can appeal to the Supreme Court if you lose at this level. However, you do not have an automatic right to appeal in this case. Okay? In fact, the Supreme Court justices themselves, they get to decide whether or not they want to hear a particular case. So the 9 justices in the Supreme Court, they get together, and the rule here is that if 4 of them see an appeal and they want to hear it, that appeal will be heard at the Supreme Court. If you can't get 4 justices on board, then your appeal is denied and the lower court ruling will stay. Okay. By and large, and this is again getting into probably about 99%. I don't know if that's the exact percentage. The vast majority of cases that are appealed to the Supreme Court are denied the appeal. Okay, so if you try to get your case heard by the Supreme Court, the only reason they're going to opt to hear it is if they think it's really interesting in terms of the legal or constitutional implications, or if they think something has been there's been some really major miscarriage of justice. So they're not going to just take every single appeal, or really the vast majority of appeals that they get sent their way. It's going to be a select few number that they want to hear. And just to briefly here go back to one of the articles I had of this graph here showing you the number of cases the Supreme Court actually rules on every year. Here we're on pace for 56, and you can go back to more, even at their more recent peaks, about 180. Okay, so there's a relatively limited amount of cases that 9 justices can hear over a yearly period, right? So the number of cases that actually are successfully appealed to the Supreme Court and have that case heard is going to be limited. If you are one of those select few cases that does the 4 justices get together and they decide they actually want to hear your case, and so it goes to the Supreme Court, you're issued what is known as a writ of certiorari. Okay, so this is a term that I think is worth knowing. Certiorari. It's not a super common term, but one you'll hear every once in a while if you read political news. Certiorari. This is the official, and this would be, I don't have italics in my handwriting, but this is in Latin. It's a Latin phrase, so it'd be italicized when you read it. It's the official notification that's issued from the Supreme Court that they are going to hear your case. Okay, so you file your appeal at the court. Most of the time you'll be rejected. If you happen to be one of the lucky few that is going to have your appeal heard at the Supreme Court, you'll get issued a writ of certiorari, and you'll eventually go and have your case heard. Okay, so again, just to recap, this is a hierarchical structure, and the exact history of a case can vary sometimes, but usually if we're getting to the Supreme Court, or at least many of the times it would be a case that starts at the district court level, is then appealed to the circuit court level, and then is finally appealed once more to the Supreme Court level. Sometimes you can go directly from the district courts to the Supreme Court and bypass the circuit courts, but the exact case history will vary on a case-by-case basis. The key that you want to know is just that the district court, this is the lowest level of the federal courts. This is where most trials are happening. You have this intermediate appeal at the circuit courts of appeal. And then finally, the Supreme Court, it's a final say. It's the most, it's the highest court in the land, whether it's hearing a federal case or sometimes it'll hear state cases, whatever it may be. The Supreme Court, it may eventually rule on a case. That's the final say. One thing I want to do here, and we're getting toward the final couple sections of what I wanted to discuss. Let's maybe talk briefly about what actually happens when you get to the Supreme Court. Okay, so relatively few cases will actually reach the Supreme Court, as I mentioned. But just what are the procedures? What happens when if you are issued this writ of certiorari, what happens at that point? Okay, let's maybe talk about the steps here. Okay, again, I guess just to reference one of the articles, this is getting now at this discussion about the public maybe having more of a view into the Supreme Court's proceedings here. So we'll get a chance to actually see what's happening at the Supreme Court more in May when they resume with these teleconference procedures in place. And so the first thing that's going to happen, so this, again, the scenario here is that you filed for your appeal at the Supreme Court. The Supreme Court has said, we'll hear your appeal. The first step that each side is going to take, so both the defendant and the plaintiff in the case, each side on the case, they will file what are known as legal briefs. And this isn't a point we'll talk about too much, just because this isn't a class on law or court proceedings, but a legal brief is just a written document that each side will file saying, here's why my side should win. Okay, here are what the legal arguments are. Here are what the facts are. Here's what the evidence is for why my side is right and the other side is wrong. So this is where most of the action is actually taking place with the Supreme Court. So again, this is not a trial court. You're not going to go to the Supreme Court and be able to call a bunch of witnesses and have a jury or anything like that. You're presenting a legal argument primarily in written form to these 9 justices and trying to convince them to come over to your side and rule in your favor. Okay? And in terms of the alternate rulings, the legal briefs, I think most would say are the most important aspect of the argument for each side, this written legal argument. And so in each court case, both the plaintiff and the defendant will file these briefs. One other type of brief, maybe some of you have heard of, again, this would be an italicized Latin word, an amicus cure brief. This would be a specific type of brief that third parties can file. Okay, so this is not, so in some cases you'll have amicus briefs, some cases you will not. So again, the plaintiff and the defendant in the case, they'll always file a brief, and then any party who thinks they're affected but is not either the plaintiff or the defendant, they can file an amicus brief as a third party. So somebody who is not directly involved in the case but feels that they will be affected by how the court rules in the case. Okay, so for instance, if there's a case, so this Louisiana abortion law case that the court will be ruling on eventually, if you're an organization that represents women's rights and you care a lot about the right to choose, you can file an amicus brief arguing for why the court should rule a certain way. If you're a faith-based organization and you feel that you're very pro-life and you want to argue in favor of the law, you can file a brief in favor of it, right? You have this right to file these third-party briefs. It varies case to case exactly whether or not the justices will read them or care about them. It's not guaranteed. In fact, it would be quite rare that an amicus curiae brief actually moves the needle in one direction or another, but you do have this right as a third party to file an amicus brief. The key action, though, is going to be the briefs filed by the plaintiffs and the defendants. That'll happen eventually. The court will schedule you on the docket to hear your case, and the next step would be oral arguments for each case. And these would be for each case, not, again, this is not an extensive process when you go in person. It's not a full trial. In fact, the oral arguments for each case are usually limited to 1 hour. Okay. So you have a case here that's maybe you had a trial of the district courts, maybe you had an appeal. So oftentimes cases will be going on for years prior to the Supreme Court. You get to Washington, D.C., which would be here, the Supreme Court building in Washington, D.C., and you've got an hour, which is split between you and the other side to make your case that you should win. So this is something to where when you talk about oral arguments, first of all, this is primarily what we're getting at in terms of the teleconferencing, right? These oral arguments will be available to view now, which we've never been able to see them before. They'll be available for the public to view. I think, again, most judicial scholars, at least my understanding of what they would say, is that oral arguments tend not to be that important. That here, again, it's a very brief period of time. You'll file a legal brief and it's dozens or maybe hundreds of pages, depending on the court limits. And the justices will have read that and understood your case in a pretty detailed manner. And usually when you get to the actual courthouse, it's going to be rare that someone will make an argument in the 30 minutes that they have to argue their case that's going to sway these justices one way or another. So the oral arguments, they happen. I think many would say they're more or less a formality, and that the legal briefs and each justice's own perspective is what matters more than the actual oral argument. But they will happen. And so that happens. You go to the court, you argue, you get your hour time slot. At that point, what happens is that the justices will get together in conference where they will deliberate about the case for however long they need to. Which, sometimes this can be an easy process if it's an obvious case that the court plans on ruling unanimously on. This may not be very long deliberations. If it's something to where one of the justices is undecided, or maybe there's a close case where it's going to be 5-4 and there's a potential for it to go either way, this can be a more involved process. So again, one of those things that's going to vary on a case-by-case is exactly how long it takes and how acrimonious it is between the justices. This is not something I don't think we'll get any public insight on, so this isn't going to be publicly televised, the private conferencing, I don't believe, by the justices. But anyway, this is just the process whereby eventually it's determined who's going to win, who's going to lose the case. So you have 9 justices, and that's an odd number, so usually there's going to be a clear winner and a clear loser rather than a tie. In the rare case where there is a tie, so one of the justices maybe can't rule or recuses for some reason, if there's a tie, the lower court ruling would just stand. But usually there's going to be a clear winner and loser based on the number of justices on either side. What happens at that point is that the court has to issue its ruling, which is referred to as the opinion of the court. Okay, so we'll actually go through a couple of different types of opinions. The most important one, the majority opinion. Okay, to where this is again a written legal document, this time by one of the justices or a number of justices on the court. They will write this document, which will explain first of all who wins, the case, and why. And the why here might entail some legal justification, some constitutional justification, or prior case law, prior rulings, in other words, maybe that set precedent. And so there are a couple of different reasons this is important. The first and most obvious being that the winner is, this is how the court announces who is actually winning the case. So this is an authoritative issuance of a ruling where the court says this is going to happen as a result. Okay, so this could be a number of different things. It could be overturning a law or an action. It could be overturning a prior criminal conviction, something like this. But the actual winner is announced in the ruling. Sometimes equally important is the explanation of why. Okay, because the explanation of why is oftentimes going to set precedent going forward. And when the Supreme Court sets legal precedent, it's binding on the lower courts. And usually the convention at the Supreme Court is to follow their own precedent, right? So the Supreme Court usually is not going to reverse itself in a similar case that it hears going forward. And so the precedent set in Supreme Court opinions is going to be very important for other similar cases that come down the pipeline subsequent to whatever the case ruling is. Okay, so the majority opinion is the most important opinion. This would be sometimes accompanied by what is known as a concurring opinion. And this is sometimes you'll have a concurrent opinion, sometimes you won't, depending on the justices and what they want to do. This would be a document sometimes issued by one justice or a number of justices, which are outlining additional considerations or sometimes different, additional or different legal considerations for why the winning side should have won. So this is, as the term is implying, to concur means to agree. So a concurrent opinion agrees with the overall majority ruling. So which side wins and which side loses. But some justice has additional reasoning to contribute that was not included in the majority opinion, or maybe alternative. Maybe they arrived at the ruling for a totally different reason. The important part here is that the concurrent opinion is not binding. The concurrent opinion does not set precedent. Okay, that's the majority opinion. The concurring opinion, and we'll talk about a dissenting opinion in a second, are more or less academic exercises to where the justice wants to put their reasoning on paper for some reason to, maybe somebody reads it and they take it into account in future cases, but it's not legally binding. Okay, concurring opinion, non-legally binding opinion, written by those justices who agree with the majority if they want to issue a concurring opinion, if they have something to add. A dissenting opinion if you know what the word dissent means, you can probably guess where we're going with this one. A dissenting opinion is written by the judges who disagree with the majority. So this would be, in other words, the set of justices, sometimes you'll have a unanimous decision, but if there's a set of justices who think that the majority got it wrong, that they think the other side should have actually won the case, they can issue this dissenting opinion to where it will outline, again, the legal or constitutional arguments for why the other side should have won. Again, though, this is largely an academic exercise. This is not, so both of these non-binding, non-legally binding. These do not set precedent. These do not actually affect who actually wins or loses. They're just documents that are put in place to offer this alternative reasoning. Okay, we're talking about the issuance of who actually wins and loses, where precedent is actually being set. It's this majority opinion. Okay, and it's sometimes concurrences, sometimes dissents later on down the line. Someone will discover them and uncover some interesting argumentation there or justification for some other case that comes across the docket of a lower court or the Supreme Court at some point in time in the future. Relatively rare, but they're written in certain cases. The important one to know, you want to know all of them, but the important one to know if you want to know who's winning and what precedent is being set, the majority opinion. Okay. So this is taking us, again, this section through what happens to the Supreme Court. What I'm going to wrap up with here is just a discussion of the appointment process for judges. Okay. So this will be the last thing we talk about in our lecture, and then I'll leave it. Actually, let me just to be more precise, appointment and confirmation. This is a process, the appointment and confirmation process, something we've talked about at numerous occasions so far in the semester. Okay. So I'm just going to fill in some of the details here. The general structure remains the same. Okay, right? This is the president, when there's a vacancy at either the Supreme Court or one of these lower levels of the court, the president will make an appointment. Before this person can actually take the office, the Senate has to approve with a majority vote. So a simple majority again. So the same process we've been talking about for a while now. Okay, so just to outline it briefly, president appoints. Handwriting is struggling here at the end. Okay, the second step here, we've talked about committees a little bit. One special type of committee that is a little bit different than other standing committees in Congress is the Senate Judiciary Committee. And this committee, as the term implies, this is where the hearings are going to be for the judicial appointees. So whenever there's a new district court nominee or appellate court nominee or a Supreme Court nominee, the Judiciary Committee is going to be the first body in the Senate to hear that nomination and think about whether or not this person is a good fit for the job. And so what's happening at this stage is usually not that high profile. If we're talking about a district court nominee, or in most cases an appellate court nominee, would not be something that makes the news, as it goes through the Senate Judiciary Committee. Sometimes if it's a controversial pick at that level, maybe you hear a little bit about it if you pay attention to some really specific outlets, but you would have to go out of your way to hear about it. When the Judiciary Committee is talked about, it's usually going to be in the context of every several years would we have a Supreme Court nominee. Right? So if you're following along with either going back to the Obama administration, the Merrick Garland actually lack of action in that case, the Judiciary Committee didn't hear his nomination in committee. The Neil Gorsuch nomination. The Brett Kavanaugh nomination. Supreme Court nominations have become very, very politically charged, and so this is where you will hear a lot about the Judiciary Committee. So specifically, if you go back to the Kavanaugh hearing, this was you recall the hearings just becoming really widely covered spectacle, right? To where everyone was covering it, and there was a lot of drama going on within the committee within these hearings, right? So it's not always going to be dramatic like that, but when you get to the Supreme Court nomination and the degree of importance it entails, oftentimes it will be controversial. Usually what happens is the Judiciary Committee will hear the nominee, and then they'll vote on the nominee. Okay, and then the standard at the Senate is that unless the nominee gets a majority support in the committee, usually the nominee will not go on to the full Senate vote. That's not binding, but that's the convention that's usually followed. In the situation in which the person does get the support of the committee, what will then happen is that the Senate will vote on whoever the nominee is, and the Senate must approve by a simple majority. We've talked about this before. And if that happens, the person will be confirmed. If the Senate does not, if the Senate opts not to approve the person by majority vote, the person will not be confirmed. Okay, this is the general structure we've talked about. One special point of discussion I wanted to bring up here that is interesting, we haven't talked about too much in this degree of specificity, is the usage of the filibuster for presidential nominees. Specifically, let's say judicial nominees. So some of the discussion here we'll have will also apply to other presidential nominees, but most of it's going to be confined to judicial nominees. We've talked about the filibuster as it pertains to legislation. So the passage of a law in the Senate, right? This is, if you go back to our discussion of the lawmaking process, the filibuster can sometimes occur after you leave the committee, after a bill leaves committee, prior to a floor vote. The filibuster is just the way that the minority can sometimes, the minority party or the minority position on a piece of legislation can delay the process or sometimes prevent the final vote from happening altogether by taking advantage of the unlimited time for debate in the Senate rules. Okay, so that still holds for legislation. Let's talk about filibusters of presidential nominees, though. So there's a bit of a different situation as far as nomination processes go. And there are 3 different periods in history which I'll talk about, and most of the movement is relatively recent. So we're going to start the story here going up until 2013. And to where this is, I would guess for most of you, you weren't following politics just based on your age that closely in 2013. But relatively recent compared to some of the other dates we talked about in this class. So the filibuster at this point, up until 2013, so from the beginning of the Senate all the way up until 2013, the filibuster was allowed for presidential nominees. So the case here being that if the president made a very controversial pick for, I don't know, some cabinet secretary, or in our case, we're talking about judicial nominees, a very controversial appellate court pick, which are oftentimes really important. The appellate court picks, I don't want to undersell them. They're oftentimes the final say on a case if the Supreme Court decides not to hear a case. So appellate court nominees can be controversial. Obviously, Supreme Court cases are very controversial. And the option was available there to the minority party up until 2013 to filibuster all these nominations that they wanted to. It was a tool, though, that was not very frequently used. Okay, what you see, however, is getting into the early 2000s, mid 2000s, and early 2010s, the frequency of the filibuster used specifically against circuit court nominees begins to increase. This is a chart showing you the percentage of successful confirmations of presidential nominees for district court seats and then circuit court of appeals seats. Okay, where the percentage here is just what percentage of the president's nominees are eventually confirmed by the Senate. The horizontal axis is different congressional sessions here. So this would be the 108th Congress, 2003 through 2005, 107, 2001 through 2003, and you can do the math going backwards. These are 2-year sessions, in odd number, starting and ending in odd number years. So this isn't a chart that goes all the way up to the present, but it's showing you this trend here specifically. I mean, I guess one thing we can note is that the green bars remain relatively high throughout this time frame, indicating that district court judges tended to be pretty non-controversial and fairly, confirmed at a pretty high rate. What you see, though, is that these orange bars, these circuit court nominees, they begin to drop here. Okay, when we get into the early 2000s, late 90s, early 2000s, Here, we're dropping below the majority threshold. It's dropping pretty dramatically in the first few years of the Bush administration. Democratic Party begins filibustering a lot of his circuit court nominees. Same thing here, we remain quite low. And so it's specifically these circuit court nominees that in this time frame leading up to 2013 begin to become controversial, and the minority party or the out party in general in the Senate begins to filibuster these nominees. Okay, so here we're talking about George W. Bush in these two bars, for instance. Both of these, or at least this, during parts of both of these, I won't get into the specific time frame, but during both parts of these, the Democrats have control of the Senate up until, I believe, the early part of 2002. So there's a sort of within term here, the Democrats gain control of the Senate. We get into this part, though, between 2003 and 2005, the Republicans gain the Senate, and the Democrats begin filibustering his nominees for the judiciary. We can fast forward in time a little bit. We have Obama gaining the presidency. The roles flipped in the Senate where the Republicans are now in the minority, and the Republicans begin filibustering a lot of Obama's nominees. And so a lot of this is going on in a sort of bipartisan way, both sides using the filibuster to their advantage to prevent nominees from taking the bench. And eventually what happens, we get into the year 2013, the Republicans are filibustering a lot of Obama's nominees, and the Democratic majority in this case in the Senate, they decide they want to change the rules of the Senate to prevent filibusters in these nominees. Okay, so we get to 2013. Again, Obama the president, Democrats in control of the Senate, the Republican minority in the Senate filibustering. Democrats, the majority in the Senate, they opt to change the rules to prevent filibustering of presidential nominees. So a pretty big departure historically speaking. So all the way up until 2013, this filibuster tool existed. So you have this dramatic change in 2013. The Senate is prohibiting filibusters for all presidential nominees. There's one key exception here, though, except for Supreme Court nominees. Okay. So those of you who were following politics going forward a little bit into 2017, you probably know what the ultimate conclusion of this story is. So here, 2013, the Senate, they eliminate the filibuster for nominees, all except the Supreme Court. What happens between 2013 and 2017? So Donald Trump wins the presidency in 2016 and takes office in January of 2017. He has a Supreme Court seat to fill as he gains that office. At this point in time, the Republicans are now in the majority on the court, and the Democrats are in the minority, so another role reversal there. Donald Trump decides to appoint Neil Gorsuch, which is a controversial pick for, I think, reasons we discussed earlier, involving Obama and Merrick Garland and their Republicans' refusal to consider him. But anyway, Trump makes the appointment. Democrats in the Senate decide to try to filibuster that Supreme Court seat. So here again, they still have that option under these rules. And what happens is the Republicans in this case in the Senate, they decide to go, to take things sort of to their conclusion and prohibit the filibuster of Supreme Court nominees as well. So in 2017, the Senate prohibits filibusters of Supreme Court nominees. Okay, so as it stands now, just to wrap up this discussion, the filibuster still exists as a tool to prevent legislation from being passed. The filibuster does not exist in any form to prevent presidential nominees from going forward. Okay? There are other tools by which the minority can sort of delay the process of appointment, or confirmation, I should say. The filibuster, though, to where you can just shut down the confirmation entirely, that's no longer a tool, whether we're talking about a a cabinet secretary, a district court nominee, an appellate nominee, or a Supreme Court nominee. Any presidential appointee, the minority does not have the power to filibuster. And again, I mentioned this, but this is something to where there's, if we're going to lay blame, if you want to phrase it that way, it could be on both parties, right? So the Democrats in 2013, they're the ones who start off the change the rules by removing the filibuster for everyone except Supreme Court nominees, and the Republicans take over in 2017, and they again complete the process here. So there's blame if if any of that isn't necessarily a negative. There are certainly legitimate arguments against the filibuster, but to the extent that there's blame to be laid, it lies with both parties here, given how we arrive at the final state of things, to where the filibuster is removed entirely for nominees. Okay, so that, there's a lot to cover here in this lecture, so probably a longer video, but that's it. That's what I wanted to talk about as far as the judiciary goes. And like I said, we've covered a lot of ground here, so if you have any questions, let me know by email, or I'll be holding my virtual office hours this week as well. What I wanted to close with is this. So of immediate concern here, we have a quiz on Tuesday, let's say. Quiz Tuesday on the judiciary. Yeah, so look forward to that. This will be the last quiz of the semester. Next week, I'll have another video posted, and we will have a review for the final. So I think this is going to be where I cut it off as far as material for the course, right? We've got enough material for our final exam, and next week is our final week of the semester prior to finals. And as promised, I wanted to spend that time reviewing for the test, right? So I think I'll cut it off here as far as the material, so there won't be another reading for next week. So I think that's it. I think that's all I wanted to say for now. Just note these two things. These announcements would be in the email as well that I send out to announce this video. Otherwise, I hope everyone is doing well. I hope you're hanging in there with the quarantine and coping with it as well as we can. Hopefully we can get back on track societally here. Hopefully we can put the virus somewhat behind us soon. Probably won't affect our semester here, but subsequent semesters. Anyway, I'll talk to you guys later. Let me know if you have any questions, and talk to you guys next week.